Okay. I'm going to, thank you for the opportunity to come and speak and share some materials. I'll bring up, so I have, okay, it was working previously. I think it'll launch shortly, yes. I'm going to begin with a clip, and then I'll talk a little bit more about the evening, but Suhail is right. I'm largely going to focus on juridical, that is to say legal space, and in particular the ways in which there's a very, I'd say, different understanding of the production of truth within those kinds of infrastructures or institutions. But let me begin by, I'll play a clip and then I'll speak about that, and hopefully we've got our volume.
Every single body is filmed and every single body is identified.
Yes, we're going to look at all that very carefully. Don't you worry about that, and experts will take a look at that too. Never you mind. But what I would like you to tell me is how, by showing the picture of a body in a meadow, set out to prove that death was caused by execution. And then you go a step further and say that death occurred through execution, and that the execution was carried out by the Serb army and police. How do you prove that by showing the picture of a dead body, of a dead man in a meadow?
So I wanted to begin with that clip, which it comes out of the, it's material evidence from the International Criminal Tribunal for the former Yugoslavia, which in fact just wrapped up last Wednesday, in fact, with the trial, the long overdue trial of Slavko Mladic, who was on the run for 16 years, was eventually captured in 2011, and that's when the trial began. So 6 years later, we have a verdict of genocide, crimes against humanity, and war crimes. I wanted to begin with that clip, because that clip in which we see the former Serbian president, Slobodan Milosevic, he makes a very provocative statement when he asks the witness who shot this video. He doesn't dispute that there's bodies in that meadow, but he simply asks, how can we tell by looking at a visual image how those people died, how they got there, et cetera, et cetera. So the dispute of what's in the image is not questioned, but what is questioned is the interpretation of that image. And this is video footage from the, as they say, from a massacre in Kosovo. And Liri Loshi is a doctor. He's still living. He actually lives in Canada. He's a doctor who heard about these events, and then very next day rushed to this village because he knew his family was living there, and he went about trying to find a video camera to document these events, so after the fact. And so Milosevic is asking, but you weren't there on the scene, so maybe these bodies were in fact put there from somewhere else, dug up from another grave, maybe they were dressed up, et cetera, et cetera. So I eventually made a documentary film about this particular piece of video evidence, and at the very end hopefully I'll have time and I'll play about 5 minutes from that documentary. So the context in which I work, or one of the important contexts for me, are truth commissions, which often involve fact-finding missions, and then legal tribunals and courts. All of these three sort of organizations, there is no such thing as a self-evident truth. Truth and facts need to be found. The Truth Commission, commissions a body of witnesses, experts come forward to debate the specific events that took place and seek some sort of redress, social justice. The Truth Commission, I'm not going to talk about that tonight, is very different from a legal tribunal. It has a very different logic, and certainly It's organized around the production of a kind of justice, and that is not specifically the mandate of a court, in fact, is not to seek justice, but is to argue the veracity or of a specific kind of case and then render judgment of one kind or another. So this is the person who was infamously called the Butcher of Bosnian, who was tried for genocide and found guilty of at least one count of genocide. As I mentioned, this happened just last week, so it's very kind of present in my mind, because the context in which his trial took place is the context where I conducted a lot of my research. So that's the International Criminal Tribunal for the former Yugoslavia. That actually starts in the 90s with the Balkan Wars. So in courts, there's no such thing as a moment of truth. That might be a kind of popular or colloquial understanding. There is no kind of moment of sudden sort of illumination but courts do have very specific kind of legal definitions of truth, and in fact, a half-truth is a legal concept, as is substantive truth, formal legal truth. So in these kinds of institutional organizations with their very specific logic and protocols, truth has a very particular status. As I said, it is never self-evident. Things aren't simply true. Arguments need to be raised. Witnesses need to be rallied. Experts need to weigh in. Judges need to weigh in on the materials. Oftentimes we would have a jury, but not in the context that I'm going to be talking about. I'm really talking about international criminal tribunals, because that's the work that I've done, and those are not jury trials. They're adjudicated by a group of international jurists or lawyers. And of course we have this very well-known phrase that we're all familiar with. So the truth is also something that needs to be told. It needs to be publicly kind of declared in these spaces. So the role of public truth-making is actually very important to the operations of these kinds of organizations. And maybe the only other final comment I'll make before I sort of introduce some of my materials is there's no such concept as something being very likely true in a court of law. The phrase that I'm sure you all know is, it's not this, what is the phrase that it's a very popular phrase, that one has to prove something. Sorry? No, I don't think so. Yeah, there's that, but there's something. Beyond reasonable doubt? Beyond reasonable doubt, exactly. So in fact, the operative modality is doubt, not truth, but the threshold of doubt. The threshold by which a doubt could be ascertained to be a probable kind of truth. And in fact, A.L. Weitzman, my colleague in research architecture, he's written a lot about this as actually a calculation. So in many instances, beyond reasonable doubt would actually be a mathematically derived outcome. So in some cases, the killing of 29 people might be lawful, but 30 would be unlawful, because that would be in excess of what was needed, the number of people you need in order to, say, gain some sort of military advantage. That's governed by this legal principle of proportionality and distinction. So in juridical space, the idea of truth, in some way, the whole concept of like post-truth is in some way it doesn't really kind of, the question of whether something is true or not it doesn't really have the same sort of degree of relevance, because truth is always arrived at through a series of complex negotiations and calculations, in fact. I wanted to, oh yeah, so just a couple of images. So two things that I have worked on is the Truth and Reconciliation Commission in Canada, and this is the judges in the ICTY. So the ICTY is the International Criminal Tribunal for the former Yugoslavia. They're both spaces that have their own sort of, let's say, organizing principles, a certain kind of ritualistic, perhaps, demeanor, but the Truth Commission as a whole is a much more fluid and, let's say, dynamic and open space and can accommodate a far greater range of evidential materials, such as, in the Canadian context, the singing of land claims that were inscribed in song rather than in legal documents with the English crown. So this court here has very strict rules that govern admissibility of evidence, and this is the site where, in some way, a state might be held to account, whereas the Truth and Reconciliation Commission is much more about, is a space that's much more oriented towards the stories of victims, and far less, in the Canadian context, no sort of perpetrators were actually allowed to really be part of that, because it was a space for Indigenous people to tell their story. It wasn't a platform, as the ICTY is and was and has been heavily criticized, for people who suffered through the Balkan Wars or whose family members died. It was very difficult for them to see how an international tribunal could offer a public platform to a kind of war criminal that went on for years and years and years. And that was very difficult for people living in the former Yugoslavia, because the ICTY trial tribunal was broadcast every day on television. And just another couple of images. This is from the TRC in Canada, and then this is the ICTY in The Hague, and there's a small number of courtrooms. It's in a former insurance building, so it's actually, it was retrofitted as a court, but it's not a very, when you go and visit it, you'll be behind those sort of glass walls there. There's more than one court, but they're actually their spaces kind of like that. They look like large infrastructures full of media equipment, and this is really important, because what I focused on specifically, because that's my interest, is largely material evidence, but specifically media artifacts. So I started to investigate this space as a processing machine itself, as a kind of very complex kind of technological machine full of glitches, et cetera, et cetera. So we'll see a little bit of that work shortly. I wanted to quickly maybe give you a little bit of sort of background insight. So this interest actually starts in my own research much earlier. It starts in 1987 with this trial that was held in the aftermath of the nuclear accident at Chernobyl the year before. This is a trial where very few people, primarily the head sort of engineer, about 4 key staff members, are tried, found guilty, and sent to hard labor camps. And so but what was also extraordinary about this particular trial, according to Soviet law at the time, it had to be held in direct proximity to the crime. So the trial was held in the Chernobyl exclusion zone, and so it was very, there's no press there, it wasn't a place that the public could even kind of enter into, so it was also a very sort of secret trial. And so Chernobyl marks, I think, the conjunction of two interests for me, the legal and the kind of material. I'm going to play my next image is this is actually quite interesting. This is the Chernobyl trial. Of course, there was no courtroom in there that they could use, so they used the local Chernobyl House of Culture, what actually became the ad hoc courtroom. So this is the town theater that was repurposed as a trial. So this So this next little, it's just a very short clip from a documentary that a filmmaker shot 2 days after the explosion at Chernobyl. And it just became one of those kind of moments that sort of captured my imagination and that really sort of spurred me on a kind of journey as an artist. And it comes from actually a rather, not a very good documentary, but this is a clip from that film.
На экране один из кадров, который студийный АТК сначала задержал как брак. Но это не брак. Это зримый лик радиации. Вглядитесь.
So the reason that that is important in the Chernobyl trial, because in that short clip, the filmmaker, Vladimir Shevchenko, he realizes when he's looking at his rushes that his film is damaged and is literally on the verge of throwing it out. And when he does actually realizes, no, the film is, the reason it's damaged is that radioactive isotopes were saturating the atmosphere, including his own body, because he did die in the end of not so long thereafter. But he realizes that what's damaged his film is the actual toxic fallout from the accident itself. So for me, in my mind, that moment where someone is making a documentary film and then the event that they're trying to capture actually becomes part of the film itself, for me, that was a shift from a representation of the accident to a sort of a capture of the real. The actual event is now permanently a part of the sort of material that he's actually trying to use to represent the event. So the index in classic photo theory, as we might understand it, the index isn't pointing to a reality outside the image. The index is internal to the image. So for me, that became a kind of an example of what I would come to call the material witness, the ways in which materials archive evidence of external events. So they register this, their encounter with an external world, but they also, but at the same time, you'd say, well, that might be interesting, but everything does. My hand on this table does, so why? It's not really relevant to say that all materials archive their trace evidence of encounters with external events, that they all carry these traces. I needed the concept that I was developing to be a bit more useful, more operative. So for me, the material witness also has to be the ways in which I follow material evidence into things like courts and really see how something like a court actually responds to this material. How does a court actually, how do materials, photographs, videos, evidence, once they enter into the legal proceedings, how do they actually disclose the very logic that is organized that space, what they think is important, who they think is an adequate witness, who needs to be dismissed. Suddenly, when lawyers and experts and prosecutors and defense attorneys, once they start to debate this material that has entered into a legal proceedings, we capture a glimpse of how that organization thinks. And so for me, the material evidence sort of starts or the material witness rather, it starts at this moment where there's a conjunction between material evidence and the law. And those are the two kind of main sort of coordinates of my practice as an artist. I'll just show you a still of a recent project that I did, which is a little bit, that also deals with Chernobyl, but in this case it's just a, David Mav has seen that, but it's a video, real-time, very slow-moving, sort of, kind of like, basically these kind of dark storm clouds. And then what you have is 20 covers of Pravda, and it was a very simple exercise. I looked and documented the day that Chernobyl happened, and I just went to see at what point did this event actually make it into the public sphere, into the kind of press. So it takes 20 days. This is 1986. It would be very different today. But now, so this is an artwork I did in relationship to this time lag between the event and its final, its entry into the kind of public sphere or space of kind of public acknowledgement that something actually happened. Of course, outside of the Soviet Union, there is a lot of sort of speculation that there must have been a major nuclear accident there, because the radiation levels throughout sort of Northern Europe had spiked, and were setting off all kinds of detectors in places like Sweden, for example. But that's this is the cover of Pravda, May 15th. So that's the first time the president actually publicly admits that something has gone on. So as an artist, for me, I thought that gap is the place where I can read the politics of the event, in that sort of temporal gap. And the reason I was able to think about this is because I didn't, if you put April 26, 1986 into a Google search engine, it will always take you directly to Chernobyl. But of course, at that time in the 80s, that would have been impossible. Basically, the online search engine has corrected the historical timeline of the event, because in fact that event did not happen then, except for the people living directly in proximity, and even then they weren't evacuated right away. That event in some way takes place 20 days later, but that gap would not have been available to me if I'd only looked at search online materials. By looking at the newspapers of the time, I was able to sort of open it up in a more kind of, I think, conceptually political manner. But now I'm going to shift and really focus specifically on the work that I did in the ICTY. So this is a demonstration in Kiev, a year after the trial that I showed you, that black and white image. And as I said, this banner reads, "We demand a Nuremberg trial for Chernobyl." This really captured my attention, because what this actually means is Nuremberg was the only model for taking a state on, or at least that was popularly understood. This is the model by which we take a state, we put a state on trial. That was Nuremberg. So this public demand in 87 in relationship to Chernobyl is a public demand to put the state on trial. That, of course, when it comes to the ICTY, this is actually what is starting to sort of happen. And these are the multi-year. If the trial started in the 90s and the last one finished last year, so several decades of court proceedings. And I just put one of my biggest challenges as an artist researcher trying to work in that context is the sheer volume of sheer volume, 9.3 million pieces of evidence and documents. The volume is massive, and the pace at which those proceedings are operating is glacial. It is so excruciatingly slow. So as a practicing artist, how do you actually narrate and work with that material when it's A, there's too much of it, and B, a trial is a set of arguments are unfolding in very kind of extremely kind of particular kind of ways, and so such that someone is debating the number of this piece of evidence. Did we give it a number? No, we didn't. Oh, we should give it a number. Oh, but didn't we do that before? And it goes on and on and on. So I started to actually specifically direct my attention to the kind of technicity of the court. And I, as a person who works primarily in video and photography and sound, I limited what I needed to look at by looking only at videos and photographs that went through the court. So that narrowed my data set substantially. This is just kind of interesting. This is the evidence vault. So when you think of a multi-year international criminal tribunal, you probably think that the archive wouldn't actually look quite like this. It looks kind of rather makeshift, and it is, in fact. And this is the evidence vault, so the most precious objects that they have are here, such as all the x-rays from Srebrenica are in these kinds of boxes. And the chief prosecutor snuck me into that because I'm not allowed to be there at all. But I wanted to show you, actually, in the first image, you can see, if I bring that up, this is just an anecdote, but oh yes, here. So there's Post-it notes, and then when I'm walking through, I'm saying, well, what are those Post-it notes for? And they go, oh, well, that's if we ever have a flood or a fire, those are the boxes that we have to save first, because those are the most valuable pieces of evidence. This is a tribunal that is, a multi-million euro kind of system, and yet, I guess I'm continuously amazed at this sort of, in fact, what seems like a rather not an entirely sophisticated manner of dealing with these really crucial pieces of evidence. So I'll just move along and just, so the kinds of things, what I did in my research over a period of maybe 4 or 5 years, I started to follow maps, models, diagrams, photographs, pieces of tape recorders. When I say I followed, I was reading court transcripts, which are, I have to say, they're thousands of pages, but luckily they're word searchable. So I would read transcripts, look for, what I thought were kind of paradigmatically interesting sort of accounts, and then I would request the video because the court is filming. It's like a television studio. There's multiple kind of cameras filming everything that's going on there, and all that material is archived. And then if you contact the ICTY as a researcher, you can say, I want this piece of footage that covers this period in the court, and so from your 3,000, say, page transcript, you select this specific kind of point, and then they send these to me and they're all low resolution. There's no sort of high resolution video being shot there. And so this is just a kind of like a broad scan of some of the materials that are in something like in the evidence vault. And you see a lot of this red marking is all, that's a special designation called marked by witness. But we also have like socks and pieces of clothing. So anything that was clothing would be photographed and then disposed of because that's considered biohazardous material. But you have models, you have images of what prisoners of war would have been eating. You have a whole range of kind of materials. And so my task was somehow to try and make my way through this material and narrate it as best as I could. And so I had to take some kind of, certainly had to take some liberties with the material, shall we say. I did a few different sort of, created several different installations. This is the latest one. So initially the project began as a 16-channel video of a 2-hour piece in which every monitor, which is here, which is the technology that's closer to what was used in The Hague. So every monitor would show, there's a different sort of portal into a sequence. And so the project was 25 discrete sequences that take you through the different phases of the court, from the appearance of the defendant to their, so the indictment, so the beginning of the trial to the time when the verdict is rendered. And so what I'd like to do is just sample some of those moments for you. I have a lot, so I'll be sort of skimming some of them and just, so the piece was called Evidence on Trial. It was my attempt to produce a project that could capture some of the kind of texture and I'd say technicity, those are my interests, of this court, and really try and understand the ways in which, if you can imagine, a war criminal, someone charged with genocide, and family members are there telling their story, testifying, and then they enter into this incredible technical machine that's an international criminal tribunal. You have an incredible kind of tension, but also, a tension, I think, emerges between the affective and emotive dimensions of what someone's saying and the kind of, I guess you'd say, the sort of infrastructure of a trial with all of its other kinds of demands, including rules of procedure and evidence and legal protocols and rituals. Ritual's not the right word, but the ways in which one actually has to speak about and manage that situation. That's very kind of choreographed. So the project really tried to capture this kind of contradiction between the material and what it was trying to, what it was trying to say, the kind of experience, and what the material evidence was trying to establish, and its kind of uptake or capture by the system. So let's begin. So this is, the project sort of begins with, sometimes I might talk on top over things or turn down the volume.
The case of the prosecutor of the tribunal against Dusan Tadic, also known as Dule, and Goran Borovnica, case IT 94-1 and IT 95-3. 94-1 and IT 95-3.
Have you want to call the case at least, or? Huh?
These are judges.
Oh, you did, I missed it, sorry.
Case number IT 9513A, I, the prosecutor versus Slavko Dokmanovic.
Good afternoon. May I call the registrar? Ask the registrar to call out the case number.
Sure. The prosecutor versus Dragoje Brunaric, case number IT 9623I.
Call out the case number.
Case IT 9936, the prosecutor versus Radislav Brjanin.
It is case IT 9834I, the prosecutor versus Mladen Letilic, also known as Tuta, and Vilko Martinovic, also known as Stella.
Please call the case.
Good afternoon, Your Honor. Case number IT 9623I, the prosecutor against Zoran Vukovic.
This case IT 9832, I, the prosecutor, versus or against Mitar Vasilyevich.
So I'm just going to
case number
turn that off a bit. So what we're first of all, I needed to emphasize the sheer scale of the proceedings, the crimes, but also the different voices. So we're hearing voices of translators. We're now attuned to the sort of like the microphone technology, et cetera. So this whole sequence, which goes on for quite a while, we see the judges that are drawn from many different countries, all of theirs, many of whom are not English speakers, so we see all of the kind of translation. So the trial, everything was translated into French, English, Albanian, Macedonian, I'm probably missing a language, but I think 5 different, BSC, which Bosnian Serbo-Croatian. So everything is translated multiple times as well.
This is the case number IT 0143. I, the prosecutor, versus Dragan Obranovic.
Case number IT 9937I, the prosecutor versus Slobodan Milosevic. Good morning, Your Honor. This is case number IT 9833/1.
So I was just going to say that's one of the very few women that was charged with war crimes. a different section now. The judges are asking the defendants, can you hear me in a language you understand?
Good morning. I would first like to verify that the technical equipment that we are using is operative. Therefore, can everyone who is using earphones in the courtroom hear me in a language he understands? Can you hear me? In a language you understand, sir. Very good. Mr. Rhodes, remember to use the microphone. It's.
I'm so sorry.
Fine, thank you so much.
Let me check whether the equipment for interpretation works. I would like to ask the accused if he can hear me in a language he understands. Can you hear me?
Yes.
Thank you.
Now let me turn next to the accused to make sure that they can hear what's being said in a language which they understand. Can you all hear? If there's
Yes, Your Honor.
If there's any difficulty during the proceedings or any proceedings before this trial chamber, if you have any difficulty hearing, will you indicate straight away?
Okay. Suhail, how am I doing for time? Okay, so I'll play a few little other bits. Some victims are actually their image would be distorted or pixelated like this. This is actually quite frequent as well. Oh, sorry. Let me just play. I wanted to play that.
Let's let the witness take the declaration.
I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth. He sat down and lit a cigarette.
There was general people were moaning,
I was about the same age as his daughter, and so he wouldn't do
People whom I knew and people whom I didn't know, and it was night time.
and leave many
They went from one person to another. They took away the people they wanted to take, places where they wanted to take them. So that is what happened to me too.
I would forgive.
Every morning I wake up, I cover my eyes, not to look at other children going to school and husbands going to work.
And feel the pain that I felt then and still feel. That will never go away.
So we've seen some of the indicted perpetrators charged of war crimes, some witness in that case. I think I will show let me show you this is a short clip from one of the technical experts, actually a British dendrologist, a tree expert, Paul Tabish, that is taken into court in the Dukmanovich trial, because this is a very interesting trial, because the defendant submitted a video alibi saying he couldn't have been at the Okara farm when a massacre took place because he had shot. He says, I have video showing that I was very far away because I shot video of a journey that I took outside my car window. And he shot just the skyline and sort of the tops of trees. So here's an expert that's called in to ascertain whether this journey that he has on video is actually true, because this is a significant alibi for someone who, because once again we're talking about another massacre that had taken place. So the tree expert is called in because there's suspicion as to why someone would actually have shot this video as an alibi out the window of a car, but because we don't see any buildings, we just see we see the sort of branches of trees and things as he's driving along.
Mr. Tavish, are there certain characteristics unique and distinctive to a particular tree which would differentiate it from other trees and allow you to positively identify it?
Yes, the arrangement of the major branches on a tree are caused by a combination of genetic and environmental factors, so that no two trees will be exactly the same.
So in this regard, trees are somewhat like people, are they not? Except perhaps even more unique, since environment also affects their appearance.
That's right. Not only environment, of course, but they are, people are symmetrical about a central axis. Trees aren't symmetrical about any axis. So if two identical trees were rotated through 10 degrees, you would see a different image of branching.
If you had two trees that are genetically identical planted next to each other, would their appearance be the same?
It would be extremely unlikely, even if there were no environmental factors, it would be extremely unlikely that they were both planted in the same radial orientation. In other words, one is more likely to be rotated around its vertical axis with respect to the other one. It would be very unlikely that they'd both be planted in the same orientation.
Is there any doubt in your mind that this walnut tree that you examine and on which you have done these comparisons is the same one that is depicted in the videotape at 1542?
None at all.
So that's a rather unusual example of expertise and also evidence. Let me play maybe, this is another, I'm playing this because it's a very short clip where there's an interaction between the judge and the defendant.
Well, Mr. Tosic, let me address you first. I see that your client is wearing dark glasses. Now, that is not normally allowed in a court. Is there a particular reason why he's wearing those glasses?
Your Honours, the main reason is the medical condition of my client, since light disturbs him and he is advised to wear glasses in such conditions. That is the only reason, no other.
Then if he wishes to apply to the court to wear dark glasses, and there is a medical reason for that, he must make a formal application, or you on his behalf must make a formal application, and it must be supported, if there's a medical reason, by a medical report. So before the next appearance, if you want, or if your client wants to wear dark glasses, then he must formally apply. Is that understood?
Yes, Your Honours. We will do as you have advised us for the next hearing.
Now let me turn next to the accused.
Okay, maybe, let me just see.
During the day, in accordance with a predetermined schedule, we would go to have our meal, and that lasted from 9 a.m. until 6 p.m. We would line up here in this area, and since we were close to the entrance of the Muya's room, then 30 prisoners would line up and then run through this main entrance to enter the restaurant. This was a self-service restaurant, a typical one, and we had to get our food very quickly. As I told you, the food was bad indeed. We would also take 1/8 or 1/4 of a loaf of bread. We would eat it quickly, take the plates back to where we picked them up originally, and then usually take the same way back, running along it, and then get through the door back to the pista and line up there. This whole process lasted not more than 3 minutes. So lining up, running, getting the plates, getting the food, eating, putting the plates back and running back.
So, yeah, very different kind of testimony. In terms of this project, I'll just play the two last parts of the project, which are in relationship to the indictment and the verdict. So there's two final clips, and then I'll just play something else afterwards.
Thank you. Your Honors, by this statement, I wish to explain to you in the simplest and shortest way possible the reasons for my guilty plea to count 5 of the indictment. I arrived at this decision on my own without any kind of pressure, threat, or persuasion by my counsel or by the prosecutors. And I decided to come before this tribunal and admit that a crime happened in Srebrenica in which I myself participated and for which I expect adequate punishment. I sincerely wish before this chamber and before the public, especially the Bosniak public, to express my deep and sincere remorse and regret because of the crime that occurred, and to apologize to the victims, their families, and the Bosniak people for my participation in this crime.
And this is the last part of that project.
Count 5, persecutions on racial grounds, a crime against humanity under Article 5 of the statute, for having committed the crime of persecutions through your participation in a joint criminal enterprise, and for having aided and abetted the persecutions against Kosovo Albanians through deportation, forcible transfer, murder, and destruction or damage to property of cultural and religious significance to Kosovo Albanians at locations specified in this judgment. With respect to sentence, the Chamber has set out in the written judgment the many matters that have been taken into account in determining the appropriate sentence. You are sentenced to a single sentence of 27 years imprisonment. Full credit will be given for the time you spent in custody. You will remain in the custody of the tribunal pending the finalisation of arrangements for your transfer to the state where you will serve your sentence. You may sit down. that concludes this trial. The chamber will now adjourn.
So I can talk a bit more about that project in the Q&A. I thought I would just show you a 5-minute, to conclude the presentation, I thought I would show you the 5-minute documentary that I made that included that very first clip, but it looks at two situations, two historical massacres, now one in Kosovo, but it compares. It looks at another one in the final month of ethnic conflict in Sri Lanka, so in 2009, because out of both of these events, a video was shot documenting a massacre. One goes through an international criminal proceeding, and the other one not at all. And the perpetrators are still at large. There has been no regime change in Sri Lanka. So the documentary looks at these two moments. I went back to both of those locations, but also had to confront the fact, what does it mean to go back to a place of historical violence where, in fact, there's nothing to see or nothing self-evident when you return to some of these sites. And this is, the situation in Sri Lanka was documented on mobile phone footage that was snuck out of the country, actually, and it made its way to Britain. And it did eventually air on public television here. And there was a sort of firestorm of controversy that erupted. And the Sri Lankan state, to this day says that this video was a hoax and an LTTE fabrication. So that's what the documentary I made tries to deal with that. So I'll play you the chapter. There's several episodes, and this is quite a different project because it's, as you'll see, the project is actually called Material Witness, and this is the chapter called Witness. And so you'll see that there's reference to two different sort of moments.
Within a juridical context, the material witness is a person who is deemed to have information germane to the subject matter of a lawsuit or criminal prosecution that is significant enough to affect the outcome of a trial. In other words, the witness, by means of the information they may possess, is considered sufficiently pertinent to the legal proceedings that every effort must be made to procure their testimony. Humans become witnesses when their knowledge or experience positions them as semantically material to a case.
Now, with respect to Mr. Tachi's tape, am I correct that this tape was at one point in time stolen by some thieves?
Yes. At the time where I was looking for this tape, his own camera was stolen. I believe not because of the tape, but because the tape was stolen because of camera, so the thief didn't even know what was in. And then, with the help of Shaban Dragai, I get a hold of this tape again.
You say with the help of Shaban Dragai, were the persons who had stolen the camera, were they members of the KLA?
I don't know.
Okay.
All matter registers evidence of certain histories. But not all materials become evidential in the sense of disclosing or bearing witness to these historical processes.
As far as the filming of the tape is concerned, you had already stated that you did not accompany at all times Mr. Tachi as he filmed. Now, in particular, with the segment that we saw earlier today, the first segment where we saw the first set of bodies, as a medical doctor, would you have expected there to be more blood at such a dramatic and large numbered amount of corpses in the same location, particularly more blood on the ground surrounding these bodies?
Would I expect it as a medical doctor? I don't know. I don't know. Okay. But I'm telling you that I saw lots of blood there. And if you look carefully at those tapes, you'll be able to see some of it too.
So I think that's a good spot to, sorry, I should stand up. So, yeah, I have many other kinds of snippets, but I think to me that seems like a good place to stop, perhaps, right? Or I don't know if I should show the next step, and I think I'll leave it there, because one of the things that I think why I wanted to end with that little bit from the documentary was also to return to the ways in which we see that by the materials that I was sort of, as I said, following through the court. We do see the ways in which the court is managing the situation, but we also see in the case of this video that Loshi shot, we also see the fact, we can also read the other history, which in some way, it's a very damaged and tape, it's very impoverished, it's not the poor images of Hito Sterl, it's a poor tape because the camera was in the ground, they had to dig it up, and then they had to find a tape, and they found a tape that presumably had taped a million different sort of television shows, etc. So, and then the camera gets stolen, and it's found again in Albania, and this really kind of degraded quality of this videotape. The argument I tried to make in that project was in some way following the logic of Shoshana Feldman, she cites a very famous example in the Eichmann trial where one of the witnesses, Kasetnik is his name, he faints because he's so overcome that he can't actually testify. And Shoshana Feldman says this moment where he withdraws from the conventions of being able to perform legal speech, the withdrawal of speech and the fainting body, she goes, that's the moment of testimony. It's the moment where one is unable to produce the coherent narrative. So for me, a lot of the evidence that you find in the vaults of the ICTY, for me, their damaged materiality is in some way a register of the kind of radical kind of incomprehensibility of those sort of events. So I think from my point of view, it plays a very kind of similar role, that the material can never perform the kind of sanitized image that maybe the legal trial would want, where all the protagonists are in the right place and we can clearly understand what's happened. So, in fact, this is the kind of evidence, if you're lucky, you even have evidence in these kind of cases of political conflict and crisis where things are happening in very kind of extremely chaotic kind of circumstances, etc. So I think I just leave it there.
I see some questions already around, but let me just kind of ask a couple to kind of frame the discussion somewhat. So I was kind of really struck. I think it came up all the way through your presentation, like the notion that truths are constructed through processes. So this, said at the beginning, there's no self-evidential truth because something has to arrive in a certain context, be taken through a process. In the court processes, it's very slow, it's very deliberate. In these extremely complicated cases, which are sort of at a state-national level, it's super slow and super complicated for various political reasons, I guess, as much as like evidential reasons.
Well, you imagine everything is being, first of all, I mean, yeah, I think it's well, there's many, I don't even know if it's political, to be honest. It's just that if you're trying somebody for the most serious crime imaginable, this is a sober decision that involves, hundreds of witnesses, corroborating testimony, looking for the paper trail, the documents, the radio dispatches. Everything is, every single fact or every single, let's say, claim that is made is cross-examined, subject to endless kind of dispute. And then, of course, the materials are logged as they enter into that proceeding. So nothing comes into the court as evidence. It is given the status of evidence by the judge. The judge will say, we will give this an exhibit number, or something else will just be a visual aid. It doesn't have an exhibit number. It's an aid to help someone testify. It doesn't assume the status of an evidential exhibit. That's done in the the process. So it's just kind of incredibly kind of laborious. And then you have the interface of all the technology, the translations, the mistranslations. Someone saying, well, the translator said this, but so-and-so said that. So the whole thing starts to
multiply in itself.
It's everything, every facet is exponentially kind of multiplied across languages and across.
But you just got to go through it, right? You can't avoid that if you're in that process.
No, I mean, you can't make kind of cavalier kind of decisions, of course, or,
Right. So I had two questions coming from that. It sort of seemed to me that you're suggesting, essentially in these processes, that there are and there have to be truth regimes or evidentiary regimes. They're not sort of spontaneous or self-generated notions of what counts as a truth or what counts as an evidence, as you've just said. So my two questions were around the process of witnessing. And it's kind of, in a way, counterintuitive to kind of humanity's notion of witnessing, in a sense, or a kind of spontaneous notion of witnessing, where you see something or you understand something and you can just tell it. And in a way, the telling of it is enough, like the subjective, the parisiastic, in a way, the parisiastic sort of telling of something is enough to count as a witnessing, if not as evidence. And what you seem to be suggesting is that because the entire structure depends upon infrastructures, institutions, processes, it's kind of laborious and sort of tedious work, and it takes a long time. The truth doesn't really arrive until the end of a whole bunch of arguments, constructions, fabrication, cross-checking, and the rest of it. So there's something in the kind of, I guess, dichotomy between this truth that you arrive at, that beyond reasonable doubt suggests a process of having doubted reasonably, and so on and so forth, against the kind of more, I guess, the spontaneous notion of the witness, even the witness to one's own sense of self or something like that, which I see is more common in the art field. Right? So just wondering how, whether you were kind of negotiating these two senses of being a witness or kind of presenting a claim, on the one hand spontaneously, and in another way, because the sort of material that you're dealing with, it's partly the material evidence, but it's also, as you showed in the clips, it's the entire infrastructures that make the material thing into evidence, and that's a very different notion of the witness to one that we're used to more regularly in the art space.
Yes, of course. I don't really work with the sort of Levinasian sort of witness, because I am working more with kind of technical kind of witnesses. That's the kind of notion of the sort of material witness. But I would say that in some way, in the documentary project, it comes a bit closer, because there's an attempt to try and, how do you actually, what are the, so in the court we have all kinds of procedures and devices, if you will, that are organized in this sort of witnessing kind of regime. There's technologies of witnessing that come into kind of play within the kind of legal tribunal. But in going back to the sites, so I'd say there might have been, for me, that's a moment where there's perhaps a different engagement with the concept of what constitutes a witness, because it was like about going back to a site of this historical violence, confronting, in fact, very little. In the case of Sri Lanka, it's more evident, and there's munitions damage, etc. But there's a way in which it's like, you know, what was my role in going back to the site? What did I hope to, in some way, witness of that event? It was clear that my motivation was to somehow find myself in that location and see, you know, actually taking my cues from Walter Benjamin to say, like, how do you look into the depths of historical shadows? How do you discern a kind of latency, an unease in these kinds of places where daily life has to continue, of course. So I'd say in that project, it's perhaps closer to the humanities understanding of bearing kind of witness, but within the evidence and trial piece, it's really looking at the ways in which, as I said, that incredible kind of tension between witnesses who are speaking, they're, you know, who did see things, who are testifying, but at every moment the court and is intervening to stop them. And so you have Loshi testifying over many years. He comes back 8 times to tell that story, and he's called back, and then what he said 3 years ago is like disputed again, and they're reading what he said. And so there's also a kind of willful attempt to negate the sort of to negate what on the part of the defense attorneys, to negate the prior testimony by finding that the witness is actually, now they've contradicted their earlier testimony. So my experience in dealing with these documents was just being, I have to say, astonished at the degree to which, for me, the court was I might have been interested in technical media, but that was the media system kind of par excellence, and it was relentless,
I kind of partly answered my second question, which is the difference between legal process of truth construction and artistic processes of truth construction, which is sort of the mega theme or the meta theme of this series. So I was kind of, the work that you concentrated on was showing how the legal process happens and the kind of glitches and sort of mishaps and the stuff that produces the truth beyond reasonable doubt but doesn't get seen as like the final evidentiary claim. And so you end up like, when the Mladic, what's the word I'm after? The Mladic
the verdict?
The verdict, thank you.
Right.
When the verdict arrived, it was kind of like that's the end of the story. So, we can just kind of, we don't have to think about the whole process. It's kind of, the court has done its work. And the piece you were showing sort of showed that actually there's a lot going on in here, and it's a bit of a mess in lots of ways, like the post-it notes and like the person forgetting that the court number already been told and all this kind of stuff. So there's a way in which you're showing the reality of the process as not quite as smooth as the court might like to present its final verdict. But in other work, like the Sri Lanka piece and some of the work you're doing around environmental disasters, there's a way in which you're kind of producing evidence. And I was wondering two things: what the relay is between the artistic production of evidence, or something that could become evidence, and the legal version of that, because you might want some of this to end up in a court system. And traditionally, these are two quite distinct types of presentation of materials. So how you negotiate that relay between the artistic and the legal. And then the second part of that was whether, I guess just whether as a practitioner you kind of feel the tension in sort of moving between the legal space and the artistic space. I mean, you kind of come from an artistic space, but because you're sort of both reflecting on the legal space but producing material to go into it, or into the policy space, or into kind of state space through environmental stuff, social violence, and so on and so forth. Whether you need to kind of compromise on sort of artistic interests of yours, or kind of like hold on to them to try and transform the legal, what they would take as evidence, and so on.
Those are a series of useful questions. I'll answer in no particular order, I guess. One thing I did want to say, and I think it's really important as a clarification, so my, let's say, meta-observations of the operations of the court. Now, I've had ICTY prosecutors taking issue with my work because they would say, like, and one in particular I had a very heated debate with, who said, like, Susan, this is Because, you know, because I'm trying to put a war criminal away. You know, I can't, you know.
Don't mess it up.
I can't be distracted by all of the things that you're interested in, which is like the glitches, the machinic nature of the court, et cetera, because, you know, when I'm, you know, if you're going on a journey, this is the analogy he used. If you're going on a journey from A to B, it doesn't matter if you go there by automobile or bicycle, as long as you get there in the end, that's what matters. So where my interest was all about sort of investigating the kind of the process, but he was making the point, and I understand it, that my interest in the sort of, let's say, the texture of that space, as a humanities scholar, as an artist, is of a different order than his very specific kind of task. So I understand that, and, you know, as he said, you know, someone could be killed. I might have many people who saw it, and yet it still takes years to put this person into kind of prison. And so I understand his point. And so, but at the same time, I'd say, as an artist, and I have stakes in the very same sort of events that he has stakes in. We both have we both have questions. We both have, let's say, shared questions and shared concerns. And I think that's, the artist still has the, in my opinion, this is where I'd say the artist has a right to deal with those materials, even though my processing is not as a litigator, for example. But anyway, so I've had very interesting kind of conversations with legal practitioners. You're asking me about, something I have been thinking about a lot, which was in relationship to, I've been thinking about and this relates to my sort of environmental work, and I have been thinking, strangely enough, about proxy data, and that is in climate science. If you want to understand the temperature of the Earth thousands of years ago, you have to look at things like ice cores, tree rings. You have to find indirect modes of sort of measurement. And I was thinking that it's interesting if we think about, there's many contemporary artistic and creative practices that are in some way gathering information, documenting events of, you know, obviously in the case of Israel-Palestine, a lot of documentary practices documenting the kind of daily life of life under occupation. In some way, there's something, I wonder, is that some sort of proxy for a process that has as of yet not happened? What are the ways in which artists themselves are engaged in producing evidential material, but it's evidence for, I'd say, a trial yet to come or a trial that may never come? So I actually think that a lot of artists are engaged in practices in which the materials that they've accumulated could, at another point, play a very different kind of role, whether even unintentionally.
Yeah. Okay. Okay. Let me see how many people have questions. There's one here. Anybody else? All right. Maybe more will happen.
Hi. It's a very kind of practical question.
Sure.
Yeah. You tend to use a lot of archives and a lot of material from the government institutions and all that. So I wanted to find out how do you negotiate these, this kind of a challenge working with government institutions, trying to get material probably which may not be available to you or they might not want to share with you, and there's a huge volume of all that sort of material available. Is there a methodology that you tend to use, or to go through such a huge volume of material?
As I said, the ICTY research would be very different. Yes, I mean, these have to be multi-year kind of projects, because you don't just stumble into these contexts and then say, oh, this material is interesting, I think I'll make an artwork about it. Because I'm also very, I'm very aware of the fact I'm dealing with extremely sensitive material that refers directly to people's experience and people who are still, by and large, alive, if they're family members. And so it's like dealing with that material in a way that has a sense of gravitas and understands understands, not, to a certain, with a certain, one would have to spend a lifetime to understand more, etc., but understands to some degree the kind of processes that are taking place there, the history, the specific kind of role. They're just kind of like laborious in terms of kind of time. And so, but as I said, one thing that it's quite important to be clear, there's a lot of material that will not make its way into the public as long as there's a kind of retrial or an appeal that might be happening. So the only materials that I could deal with are ones in which there's no, the case is, there's a verdict rendered and there was no interest in appealing the judgment. Those materials then become public kind of property. And they're in, the ICTY is a UN body, so they become part of the UN's archive. I think what's perhaps not what you asked, but which is really important is historically those materials after the trial all go to New York City, and this is where they're stored and archived, and that's like case closed, move on to another sort of situation. There's been enormous pressure in Bosnia, in Croatia, etc., that these archives somehow have to stay in the region in which they matter sort of most as pedagogy, etc., etc. So the archive itself and all its holdings is very contested in this case because there's a lot of dispute around who can actually access this material. And to answer your question very kind of quickly in that sense, the discussion I was having with this prosecutor was saying, like, these are public materials, and he has had a very I'd say proprietary relationship to these materials. But I said, at a certain point they're going to be publicly available, and one has to sort of accept the fact that different people will work with those in very kind of particular ways. The one thing I would say, because it required a lot of editing on my part to find moments that I thought distilled a kind of useful sort of moment in a case, that was very time consuming. So they're not the kind of materials that one could quickly find something and do something kind of like, sort of like, in some way they're harder to misuse because it takes a lot of work to find these sort of moments that you can actually utilize to sort of make a point about the nature of those kind of sort of spaces. So I would say they don't lend themselves that readily to being kind of used in a really kind of ad hoc, casual sort of kind of manner.
There's one there. Could you just wait for the mic?
About the use of your stuff around your work around the use of video, and obviously there's a lot more video being used these days. People shooting videos on their mobile phones, and you're looking at the sort of materiality of the evidence that you shot the mobile phone, and it shows that moment in the action. And I'm just thinking about sort of evidence that's coming out of Syria at the moment, and then ideas of sort of and fake news and this whole kind of moment we're in now, of people kind of faking this sense of authenticity, and what your thoughts are around that, and how much materiality can be ascribed to this video evidence now. It's sort of become a style or a technique. I mean, back in the 90s there weren't so many videos, but now there's a lot more.
Yeah, I mean, I guess some legal experts I've talked to, there is, you could say almost in some way there's an excessive material on some level, but of course, in order to actually have legal standing, material really needs to be authenticated, and this is why there's a lot of work on the part of organizations like witness.org, etc., trying to ensure that activists taking video, that the metadata is kind of correct, date, time, etc. If you have a GPS-enabled phone, then of course is much easier than the metadata can be reasonably accurate as to time of day, etc. But that's part of the lawyer's job, is to ensure that there's a difference between the materials that we see on news broadcasts versus something that will actually hold up in court. That's an entirely different kind of piece of video evidence. So something that works in the domain of public advocacy may never have any kind of legal kind of traction. If it's been captioned, if it's been edited, if there's a cut, I mean, all of these things become like the place where a good lawyer will say, well, there's a straight cut there. There's a jump cut from one scene to the other. What was removed? What was so the minute you enter into a kind of, that's the job of a lawyer, in fact, to ascertain what they say, the probative value of these materials. But certainly, there's no question that there's, I wonder how, if, hopefully there will be a trial, but if Assad was ever to stand charges of war crimes, I wonder how that material would be managed, because we're talking about, presumably millions of images and video clips that have to be all organized in some fashion, both on the part of prosecutors and defense sort of attorneys. And that's something they talk about a lot in The Hague. The lawyers will say, it's impossible to keep a case in your head as a lawyer because the case might take 3-4 years, have thousands and thousands of pieces of evidence. So even you, as the person prosecuting, don't have all the parts, can't manage that. It's an interesting kind of question, but there's the question of I think new technologies they will definitely assist with the corroboration of date and time and location where things were shot, et cetera, But here's an interesting example. In the case of Sri Lanka, where the state said in fact, that was a faked footage. There were 2 UN commissions that looked into, that did a forensic video analysis on the mobile phone footage. They didn't have the original. They had like a digital file, and they came to the conclusion that all the injuries depicted seemed consistent with actual wounds of that kind, etc. So there was actually 2 UN commissions that said unequivocally the video was authentic. But the state, the Sri Lankan state, what they did is they looked at who the video experts were that the UN was using. One of them happened to be happened to make a very controversial decision in a Canadian case where a Polish immigrant was killed by taser in the Vancouver International Airport, and another passenger caught that on video. And the RCMP were exonerated for killing this man. They said he was menacing. It said he was brandishing a stapler. And but the video expert in this case found favor with the RCMP. And after this amateur video footage arose, he was completely shredded as to his findings. His credentials were. He had actually falsified his credentials. Now the UN happened to use the same person. So it didn't even matter whether the video was fake. The expert was actually seen to be actually a kind of dubious character.
Can I just use the mic? It seems to me that in response to this is quite an interesting shift from the notion of texture. Because last week at Metahaven we were talking about producing textures which are kind of effective narratives and do work within like a mediascape and so on. But that texture was very much at the level of the image that you receive and the kind of structuring devices around it to make it look convincing enough in terms of verifiability. So I think in response to this, it's a bit like the issue would be whether the evidence that's presented accords with a rhetoric of an immediate image, something that's kind of loud in your face, which circulates very well on social media, rather than the sort of tedious evidence making. So you kind of talk about producing a texture which gets you beyond the reasonable doubt line through kind of network, and something similar is happening like on the social media scape in terms of like post-truth configurations and so on. But there are obviously very clear differences about how those textures are produced and what they are. But as kind of what it suggests is actually the whole image construction space, not just if images become evidence, the evidence itself is a kind of process which needs to be constructed. But also the images themselves are constructed now, right? And I was wondering, in terms of your practice and the kind of scales at which you're working, which are kind of like environmental catastrophe, social violence is on kind of communal levels, ICT, these are kind of large-scale projects. I guess the question I'm asking is, given the kind of enormity of the database, the length of the trial, and even the lawyers can't hold on to the case, whether it's really viable to think about dealing with issues like this, and there's increasing interest in dealing with climate change, for example, in that kind of scale of problem, whether it's possible or tenable to kind of think about individual artists dealing with this on their own. So with forensic architecture, which you were a senior researcher on, I think, when it was still a research project rather than an agency, it's a group of people, and collectively you kind of gather some material, turn it into evidence, and then sort of pitch it at various levels. But I wonder, just as a more general lesson, whether the notion of the artist as a kind of individual agent or witness, or somebody who sees something that other people don't see and needs to kind of report it, and so on, whether that's going to be enough to kind of do the sort of work that are actually the political claims, or the kind of the critical content claims of the practice. So you need collaborative, large-scale texture-making kind of organizations or structures to kind of turn this stuff into something that can do the work it wants to do.
Yeah, I guess so. I mean, I would use my most recent experience in the Netherlands, which is I was working with this small group of scientists who are out of the University of Delft and also the Dutch Meteorological Institute. They work at this place called the Cabau Experimental Site for Atmospheric Research.
So the one I showed in the intro.
Yeah, you just showed that. I mean, so that was a case where I'd been there several times talking to them, and I was, first of all, I went there, I already had an interest in the ways in which climate science uses the concept of feedback, so but what struck me when I spent time there, and I also ran a workshop there, was the degree to which we kind of had a shared vocabulary. So they were calling, like a cloud was just noise, because they're gathering the atmosphere is a data set, and a cloud is a form of interference. And so my sort of background also in media theory was like, this is really interesting how we're sort of almost speaking a similar kind of language. They're also they use a lot of acoustic instrumentation to listen to the atmosphere. So acoustic is really important to the work that they're doing there. And I said, I would really like to come back and work on making a kind of documentary film where we sort of explore in some way the ways in which they actually had, I thought, an extremely kind of aesthetic and understanding and sensibility of the materials that they're working with, the ecological materials. But not only that, when I was there, the couple of things that came out, and this was just pure happenstance. One of them was they mentioned Joseph Beuys, and which I didn't expect them to talk about. And they go, well, Joseph Beuys actually made this, they said, a very provocative claim that Dutch light had disappeared with the land reclamation project. So that Beuys argued that the amount of water molecules in the air had disappeared, because basically land reclamation projects, communities, like these very kind of famous, these locations where all the sort of very famous Dutch landscape painting had happened, were now further from the sea. And so Beuys claimed that the light had, the atmosphere changed, and Dutch light had disappeared. And they found that very interesting. And so I thought, well, first of all, there was this kind of knowledge of Joseph Beuys. And then another thing they talked about was, in this particular case, was the Dutch landscape painter Jacob van Riesdael, who painted, I think, 694 paintings. And this is where the idea of proxy data comes in, because they were saying, we don't know what the atmosphere looked like in the 17th century, but we have these Dutch landscape painters that were kind of obsessively documenting clouds, cloud formation, and skies. And we're looking at these art historical paintings to understand atmospheric conditions in the 17th century, because most painters actually didn't travel that far. They were painting largely in this sort of same kind of location. So there's this incredible visual archive that it produced, and the scientists there, understood the value of that. So I thought this is a kind of, for me as a practicing artist, that this is a really kind of interesting conjunction because of their sort of understanding of a cultural object as a important source of information for them, because the kind of information that they can ascertain, they've got technical probes to deal with now, but they can't deal with the sort of
300 years ago.
Yeah. And so I think you have to find people like that where there's. So for me, it wouldn't. Yes, they're dealing with climate science. Yes, it's a planetary scale phenomena. At the same time, I had to find a way of telling a very kind of small story, and finding people who, I found very philosophical. In the end, they were very philosophical kinds of scientists and really fantastic subjects. And the way they talked about things was, I thought, very, would be really, had a strong affinity to a kind of artistic, creative understanding of things.
Okay. All right, let me buy you a drink at the bar. Okay, let's thank Susan for